Deputies are ready. Mr. Koopmans, you may begin.
This may please the court. If it were not for this court's decision in 2000 in Here versus Thola, I would not, pun intended, be here. No one as an original matter, I think, could read the statute and say, at least that was involved in this case, and say that it applies, the statute of limitations that applies to these claims. The district court certainly did not think so. And even counsel for Wells Fargo seemed to not think so. In the filings at appendix page 24, counsel said, not until I discovered Here did I realize that this statute of limitation applies to these claims. And the reason for that is on the face of the statute, which says that the statute of limitations, which says that it applies to adverse claims that are by reason of the transfer from the trustee. And then it says again at the end that the one-year statute runs, or it sets into place more than 1 year after the date of recording of the instrument from which such claim may arise.
Mr. Koopmans, I'd love to defend the author of that opinion. Nothing has really changed. You're just downright asking for a reversal. Am I correct?
And so I say that because, original matter. So all of this is about Here versus Thola. And with one caveat, and we'll get to that in a second, because Here only involved a action for boundary by acquiescence. It did not involve a claim for adverse possession. They are two very separate doctrines, and the underlying reasoning of Here does not apply to adverse possession. So I'll get to that in a second. But just hitting Here head on right now about whether this court should overrule it. So number one, as I said, it is clearly wrong. It wrote those words out of the statute. And while stare decisis has its place, there are no principles of law, there are no principles of stare decisis at play here that say you should keep it. There's
2008, I think, the legislature revisited the statute and made some changes to it, and that would have been after Here. Can you respond to how that changes or how that affects the stare decisis decision?
Legislative acquiescence is a doctrine. I think we can debate about how strong it should be or not, but there's always been the exception, which means it's not ironclad. And if it's manifestly wrong, kind of on a degree, how wrong? And
more than legislative acquiescence. This is in 2008. There's a bunch of trust-related legislation. I assume the bar association's involved, like they always are. And this specific provision, there's a section that says this provision is amended to read as follows, and they leave that language alone right in there, and it's only 8 years after Here. So it's a little more than acquiescence, right? So it assumes kind of this whole thing is, I believe that would have to say you can, once that happens, once the legislature amends a statute, you can never, ever overrule a case. And I guess, what is the basis other than just that it was decided that you would leave it be? And there are instances, and this is exactly one of them, where the error in Here does not touch any wide swath of people at any individual time, such that any association up at the legislature is going to flag it for anyone.
Have to assume generally in our cases that the legislature knows the status of the law when it passes laws. It knows the common law, and then it knows the cases that we've had interpreting words in statutes that are in place.
Well, I think generally, yes, that is, all of what you're saying is true. And I guess, is there any other reason other than that one to keep Here in place? And so I'll go to that second point, which is Here did not just interpret the statute wrongly by reading out the language such that the claim has to be tied to the deed, not tied to actions about acquiescence or adverse possession. But the case, and this is to defend the author of the case started off on the wrong foot because of how the parties framed the issue. And so the entire case gets a Chapter 650 claim completely wrong, so much so that it raises that it puts in play the constitutionality of Chapter 650. In Gates versus Brooks, this is so tracing back the cases to what a Chapter 650 case means, and what then Judge Mansfield said in Georgia Pacific Gypsum that statute of limitations can't apply because it's not about title. So if you go back to Gates versus Brooks, 13 Northwestern Reporter 640, there was a challenge to Chapter 650 because the defendant requested a jury trial. And he said, because there's no right to jury trial, because Chapter 650 proceeding is a special proceeding that deals with the commission, it violates a right to trial by jury. This court said, no, in fact, it doesn't, because it's not about title at all. It's not about who owns anything at all. It is taking the deeds and applying it to the earth. So in here you have lot 43 and lot 44. The first part of this case is a Chapter 650 proceeding, and it's just, where are those boundaries? And the legislature has created, it came through common law, and legislature has created
614 refers to an adverse claim. Is this an adverse claim?
because it's not a claim at all. It's not about claim about who owns title. So again, you see and hear over and over again, they talk about title by acquiescence. A Chapter 650 claim is not about title. It's just about having a commission draw the lines of where Lot 43 begins and ends and where Lot 44 begins and ends. Who owns those pieces of property is left for another matter. And depending on how those lines are drawn, then you might go to the adverse possession claim. That is an adverse claim, but doesn't apply because it has to be tied to the deed, not the adverse possession. So if you say here stands, and the court clearly in here did not perceive it to be overruling precedent from this court from the 1800s saying that you don't get a right to trial by jury, and that title isn't at issue in a 650 claim. And that's what the Court of Appeals opinion, what then Judge Mansfield said in Georgia Pacific Gypsum.
Case.
Counsel, so just kind of stepping back a little bit, 614.14 is a kind of a title clearing statute, right? Is that what it is? And your position is that a boundary by acquiescence is not a title issue at all. It's where are the boundaries?
Call it a title clearing. I mean, there's different provisions because subsection 1 clears some, and then subsection 5 is a statute of limitations. I guess
They kind of work together. So to subsection 1, that was, I think, the impetus for why they made the change in 2008 to subsection 5, because they added some things into subsection 1. And they identified specific statutes that are covered by what a bona fide purchaser gets.
are dealing with the spouse.
Those are adverse claims. And so, but then they update the adverse, or the statute of limitations provision to say in A, that a person holding an adverse claim arising prior to January 1, 2009. So that's kind of before we changed this and added these other two provisions to what is an adverse claim. Now you've got 2 years, and beyond this, and you only have 1 year. But so that's still just addressing what is an adverse claim. And so your position is that a boundary by acquiescence is just not an adverse claim.
And it's this court's position, at least it hasn't been overruled.
On our prior case law. Okay, but then you said that that an adverse possession would be an adverse claim. Okay, but it's the arising under. Okay, but here's my problem with the arising under. Doesn't a claim related to spousal rights that were added in subsection 1, that doesn't arise under the deed that was issued by the trustee, does it?
Wipes those claims out. It's not a statute of limitations.
Okay.
So that's on the day you sell it, those are wiped out. And then subsection 5, you get a year.
Updating the years in subsection 5 then.
Years, because there's before and after, I don't know why, and they just updated them, which I think if you dig into the years and why there are even years there, it makes here even more confusing. And so I'll quickly move on to the adverse possession claim. So the foundation for here, if there was kind of any reasoning for it, was that, again, wrongly, they said title by acquiescence doesn't vest until you get a court order to say they have acquiesced. Again, that's a fiction because there is no such thing as title by acquiescence, but kind of assuming that's the case, that is definitely not the case for adverse possession. This court has said you gain title, even marketable title, after the statute of limitations, the 10-year statute of limitations runs. So the Vaught's owned this property after the statute of limitation runs. And the court in here conceded that you can't give away more than what you own in that sense. And I don't think Wells Fargo would want to actually wade into that area. That would probably be problematic for them. And so the district court gave no reasoning for extending here to adverse possession claims, nor does Wells Fargo provide any.
If we don't overrule here, what practical problems is that case continuing to cause, especially if it's not applicable to adverse possession claims anyway?
One, it allows people to play games. If I own a property for a long time and I have long acquiesced to my neighbor having the boundary somewhere else, but then a new neighbor comes in whom I don't get along with, and I say, you know what, I want to take that back. All I have to do is create a trust, deed that to a friendly party, maybe even myself, and I don't move out, so nobody even knows I deeded it, and then wait, and then after a year's over, I come to my neighbor and say, you know that shed that you built here? That's mine now. I mean, there's no way that and then Justice Katie had it completely right. You can understand why the legislature would say that there's a statute of limitations based upon kind of the trustee's authority, something to do with the trustee. But why would a trust be so special that you would just protect it from any claims going forward that had nothing to do with the trust? Why is that different from a deed that comes from somebody personally as opposed to if they were a trustee? And if you keep here, there are all kinds of games that can be played with it. And again, there's no rationale. There's not even a reliance interest because there's still that 1-year gap. Wells Fargo still has just as much incentive to make sure that it does its due diligence based upon acquiescence or adverse possession when it issues a mortgage because there's still that year. And it also would just create unneeded litigation. If I've lived in harmony with my neighbors forever, now I hear that they transfer the deed. I ask them, well, it's a trustee deed. Well, I need to immediately issue a lawsuit against my new neighbors for fear that if I don't, if in a year and a half those new neighbors decide that they want to take over what I have considered my property, then I'm out of luck.
To use your shed example, if the shed's been there for more than 10 years, say, hey, I don't care about that deed game you just played. That's my shed based on adverse possession.
Well, there are also always different elements that apply, and so there are two actions here, and so I wouldn't want to leave it just to adverse possession, nor, again, what I think that the court wants to kind of throw open the whole meaning of what a Chapter 650 proceeding is. And so in this case, when it's a legal fiction, but if they win, if the Vaught's win because that's what they want, this Chapter 650, and the court says the true line, and this is what the court has consistently said, boundary by acquiescence, when you find that is the, quote, true boundary. Obviously that was created well before we had geolocating and everything like that. So it was easier to just set the boundary where everyone had done it. If they do that, then it just means that is part of their lot 44. We don't even move on to the adverse possession claim because it's just part of the lot for which they already have title. If there are no other questions, thank you.
May it please the court, my name is Scott Hall. I'm with Carney and Appleby Law Firm. I represent Wells Fargo, who has a purchase money mortgage against the real estate at issue in this proceeding. This is a case of statutory interpretation of Iowa Code Section 614.14, entitled Real Estate Interest Transferred by a Trustee. I've always personally called it the belts and suspenders statute because I know of no other title clearing statute that requires so much of the conveyance documents as this one does. About 80% of my practice is real estate and estate planning and probate. I do this every day. I review about 400 to 500 titles each year. When a trustee is conveying a property or a trust is conveying a property, this statute requires an affidavit from that trustee declaring that there are no adverse claims whatsoever against the trust or the transfer. It requires a trustee warranty deed.
And an adverse claim, why are actions under 650 adverse?
Defined by the statute, Justice McDermott, subsection 3 defines specifically and explicitly what an adverse claim means, and that includes a claim that a particular adverse person is the owner or has an interest in the real estate. That includes a claim for boundary by acquiescence, a claim for adverse possession, a claim for any kind of title. That is very broad, and I think it's intentionally broad. As I was saying, the trustee warranty deed requires that the trustee, in addition to the affidavit, certifies certain things are in place with the title as well. And then the purchaser also has to certify under oath an affidavit that they've relied upon all this information. This is a special limitations statute in the special limitations section of the code, and it is specific to trusts for a reason. Trusts are alter egos. They are legal fictions. They are not registered anywhere. They are not public records that you can go to the Secretary of State and find out about them. They are used by people mainly to convey property after they die without the use of a judicial process or probate administration. So in order to give lenders like my client and buyers, bona fide third-party purchasers, the confidence in the title of real estate, we have put these requirements in the code in 1992 to make sure that the title is clean and there's nothing that is not of notice to the buyer.
Answer about adverse claims in the code. I guess I'm not sure that I follow. It doesn't reference Chapter 650 specifically. And the boundary by acquiescence, it's not a title issue. I mean, it's just defining the property line or the proper property line between adjoining lots. So how does that fall within adverse claim?
Well, I think the broad definition in the statute itself that a particular adverse person, in this case the Vaught's, is the owner or has an interest in the real estate. I think by claiming the boundary line is really not where you think it is, it's further over. And Mr. Koopmans even conceded that once the boundary by acquiescence is successful, then they would say, we've always owned that land. That certainly fits the bill as an interest in the property.
Those two things? I mean, we can say that fixing the correct boundary line is a different argument than who has ownership over the property once the boundary line is fixed.
We can, and we have. I don't disagree with the line of case law that suggests it's not a ownership issue for boundary by acquiescence. But I would like to point out that this is intentionally broad in this statute. When you look at the legislative history, and Justice Oxley alluded to it, but this statute was, before 1991, called recovery by beneficiary of a trust. It was a 10-year statute of limitations that really only protected beneficiaries and spouses trying to get at property that was transferred by a trust and they had no knowledge of. 1991 to 92, they completely gut that statute. They bring in what we see today and what was in place for the here decision. And they intentionally made those adverse claim definitions broad. The reason I say that is 2013, they amend a statute, they add a statute right after it, 614.14A, that covers entity conveyances, so LLCs, LLPs, companies. That has a very different definition, explicit definition of what is an adverse claim and what is not an adverse claim, and it leaves out all of this broad domain that is in the trust statute. That's why I think the legislative was intentional about what they did. I also want to address what Mr. Koopmans said about my standing with the here decision. I completely disagree with what he characterized there. I think the here decision was correctly decided. I expressed some sympathy to the parties in my pleadings about the position they found themselves in. But when you look at that here decision, it was a 4-2 decision with one justice abstaining. And I do want to point out that Justice Cady's reasoning has some flaws in it. And one of the big flaws is he misquotes the statute. The quotation he uses, the language arising by reason of, does not appear in the statute. In fact, in 2000, the statute said, and I'm looking at subsection 5, part B, An action based upon an adverse claim arising on or after January 1st, 1992, comma, by reason of a transfer of an interest. So the arising part is talking about the date. And that's what they changed later to make it 2009. It's not, and then he compares that to arising out of from the workers' compensation cases. So he conflated the language there that really changed the meaning. It's actually arising on or after such and such date, comma, by reason of a transfer of an interest in real estate by a trustee. Now, I understand that Mr. Koopmans and his clients believe that by reason of a transfer is really the problematic language here. I did a simple Lexis search of Iowa code for by reason of, and it appears hundreds and hundreds of times in the code. Most of the time, I find that it is just a simple but-for causation used in the statutes, but I invite you to check those yourselves too.
That, I mean, because, so you're saying, I guess the problem is that the Vaught's claim really doesn't have much to do with your interest, is sort of their position. I mean, say a little bit more about this but-for interest, because by reason of a transfer of interest seems stronger, at least to me. I don't know.
Well, I think the simple answer and what they found in here is that the buyers, the enamorados, they would not be a part of this litigation whatsoever unless they had purchased the home. They are a bona fide purchaser as is defined in the statute based on the pleadings taken as true. And because of that, they had to be brought in. But also, Section 5, subsection B, also refers to an interest in or claim to such real estate, legal or equitable, against the holder of the record title. That, again, is who the enamorados are. There's been a lot of discussion about adverse possession conveying marketable title, and there are some case law about that in the Horn books and in Iowa's common law. But in fact, it's not a record title. There are cases in Iowa law that say you cannot provide record title to an adverse possessor on affidavits alone. I've got a cite on one of those cases I'll be happy to give to you. But I also just think in practice and in reality, there was no way for any title examining attorney to have any notice whatsoever that the Vaught's had a claim against 0.14 acres that neighbored the enamorados when they...
Whether there's a trust involved or not? I mean... All right. I mean, it seemed to me a few minutes ago you were starting to give us kind of a policy explanation for why the statute, might make sense. Mr. Koopmans made an explanation for why it doesn't make sense. I mean, explain to me kind of why, because I'm not a trust person, why this makes sense in your view.
Sense probably more for my client, Wells Fargo, and the national lenders more than anybody else from a policy perspective. Because like I said before we had statutes like this, the bank might require a full copy of the trust be filed or a trust certification be filed. And that would cover, hey, this is who the beneficiary of the trust is, who the grantor of the trust is.
To the trustee's power, and who cares in this case, right? I mean, that's really not what's in play.
So what I was going to say after that is that's only part of it. So in my practice, what I've seen is the lenders are very, very wary about lending to trustees who own property. And the only way to get past the probate administration in this state is to put your real estate in a trust or an LLC or some other entity that can circumvent that probate process after you die. So a lot of people use revocable trust, even if they just own a small home, because one piece of real estate with one person's name on it will put you into probate. So what I've seen is a lot of lenders in our market, they will force the trustee to quitclaim deed it back out to themselves as grantors because revocable trusts are not separate legal entities for tax ID purposes. They run under your own social security number as long as they're fully amendable or revocable. So they will quitclaim the deed back out to, in this case it was the Sears, Nicholas and Barbara, who sold the home. then refinance it, make the mortgage signed by them individually, and then they'll quit claim it back into the trust.
If it happened here, this statute would not have run, right? So again,
Individually, this statute would not apply because it only applies to trustee conveyances.
this is a trustee's deed matter here.
Statute. It's applicable because of the way it was written and the place it was put in the code. And I understand the argument, and I empathize with the argument that that's arbitrary. But I also think it's arbitrary for a neighbor to claim that for 30 years, their neighbors acquiesced to a boundary and everybody knew it, but they never took any step to make it a record in the public record to put everyone else on notice. How is that any different? For 23 years since here, we've had no other challenges to this statute. The reason I said in that pleading that once I found the here case, I had to bring it forward because it's true. The here case is almost identical to this case. I went and found the statute. I looked at the annotations. There's one case. It's here versus Thola. And I do believe here versus Thola was correctly decided.
To respond to opposing counsel's point that the claims that are defeated in subsection 1 of 614.14, he said that they're immediate and they're gone. And so there's no ability, so the statute of limitations, the 1-year statute of limitations in .5 does not apply to those claims. Someone that has an adverse claim is just done. They don't have an opportunity even within a year to come in.
The way I read the statute, Your Honor, to me, it says free of any adverse claim, including but not limited to claims arising under section 561.13 or 633.238. I think the only thing that changed was it made sure that those spousal claims are included in the definition of adverse claim.
Would still get to at least bring their claim within a year.
But I could be misreading that, but when he said that earlier, that shocked me because I had not read it that way. And frankly, if we give the appellants what they want today, I think we're putting adverse possessors in a better position than a surviving spouse or a spouse whose husband or wife sold trust property without their knowledge. And I think that's a definite fear.
To the arguments that if we don't overrule here, we're allowing games to be played.
Agree with that. I mean, I don't think there's any evidence to show that games have been played. I mean, the other reason I have empathy for what's going on here is these are neighbors, next door neighbors. These are homesteads in a nice West Des Moines neighborhood. The hope would be that the neighbors would get along and they would decide on these things on their own. There's not a lot of cases like this out there. That's why we haven't seen one up here for 23 years. I think trusts are expensive. Trusts are also very confusing, even for the most learned of professions. I have a hard time talking single persons into simple revocable trusts when they want to avoid probate for that reason. Like I said before, it's a legal fiction. It's an alter ego of yourself, but it's not a separate entity, so to speak. I don't see the implications being dire at all if here is upheld. I do see bad implications for the financing of real estate markets in this state if it is overturned. I think everyone, at least in the 15 years I've been practicing, they are accustomed to this trustee affidavit, purchaser's affidavit, and the trustee warranty deed that all use the statutory language to make very, very clear there are no facts or legal claims which might impair the validity of the trust or the validity of the transfer, which is stated right in the code as well.
Was aware that there might be a boundary by acquiescence and filed that affidavit, then that would be a false affidavit.
Chief Justice, my time is up. Could I respond? I do believe that would be a false affidavit, yes. Thank you.
All of the justifications that you just heard for why here should not be overruled are not based on the statute of limitations. Because within that year period, all of those things are true. If you sign a false affidavit, if there is an adverse possession claim, if there's a potential action for boundary by acquiescence, all of that can be done inside of a year. So that's where subsection 1 is what Mr. Hall is referring to is a bona fide purchaser rule. A statute of limitations is not a bona fide purchaser rule. In fact, my clients were set to, it's in the record, my clients were set to file an action inside of a year, but thought and understood, perhaps wrongly or not, from counsel that things were going to be worked out. When they didn't, they filed 3 years, or 3 weeks after the statute of limitations. Nothing what you heard here as to the policy reasons or even the statutory interpretation reasons would matter, that you still have to think about that 1-year statute of limitations. As far as the definition, the kind of causation, what this claim, the statute of limitations applies to and how it arises out of, and Mr. Halls had noted that the beginning of the statute changed ever so slightly. Pay attention to the very end of the statute of limitations of subsection 5. Again, it says that the statute of limitations applies more than 1 year after the date of the recording of the instrument from which such claim may arise. That's the original one. This is in here. So the claim still has to rise out of the instrument, meaning the trustee deed. The adverse possession claim does not arise out of the trustee deed. It is not even relevant at all to the proceeding. It's all of the elements of adverse possession and the length of time. The amoratos aren't even really figured into that, except for they are now the proper defendants. So that's the only reason that they're there. That's the only relevance, I guess, the trustee deed has.
Logic then, does this only apply to adverse claims that relate to the trustee's deed itself? And so would a, like a 633, 238 surviving spouse claim, does it arise out of? Doesn't that have the same problem? It seems like if arising out of is only arising out of the deed, then any adverse claim other than something related to the trustee's deed would not be subject to the statute of limitations.
Related to the trustee deed, so related to the trustee's authority.
So this is really just limited to, as you're reading it, an adverse claim subject to this 1-year statute of limitations is only the type of adverse claim that arises out of the deed itself. Powers.
Related to, arising out of, correct. And I guess I would just kind of repeat to state the obvious. It's not what I'm saying. I think that is literally what the statute says.
It's right, though, that if you just take a strict but-for cause, but for the trustee deed, there is no cause of action, right?
That would be like, again, it has to arise out of. So if someone falls, and so the trustee deed created a new neighbor who was angry, so then but for the new neighbor coming in, there never would have been a lawsuit because the previous ones had acquiesced. And so, yes, but that's not how statute of limitations work. So if someone falls in my driveway, actually happened, breaks their shoulder, and they decide not to sue. They're not going to sue, and then we get in a fight. But for the fight, and now we're not friends anymore, they would have sued me, that the claim doesn't arise out of the fight. It arises out of when they fell. These claims all arise out of the acquiescence, all out of the...
You have the better reading of the language, but again, we have to overcome stare decisis and this argument about what the legislature did.
In this case, all of these principles, again, going back to what a Chapter 650 claim is and completely changing that. And then also here, if you are changing what kind of but-for analysis means in a statute of limitations, I guess you would have to cabin this and saying, this is we all recognize this is the most wrong case, manifestly wrong, and none of the logic makes sense, but we're just going to keep it. So now we are permanently rewriting the statute to say, if there's a trustee deed and you have any kind of adverse possession claim, you cannot sue after 1 year. Okay, and also now what happens when there's another sale? This time, trustee deed sale to a person just deeds it to another person. Now, with the third neighbor, now there's a dispute. Then the question is, does that arise out of the trustee deed? Because but for, this never would happen. This neighbor would never be there. And so I think you have these problems. Where do you go from here? Thank you.
Versus Wells Fargo is hereby submitted, and court is adjourned for the morning.